Is there any question? Yeah, please.
For your first case about McDonald and McDonald case, I would ask if the Supreme Court thought about whether the case is a good one for the equity to intervene to secure the fundamental right of the young lady.
A good case for who to intervene?
Equity.
Equity.
Yeah.
Okay, so I suppose the technical answer to that question is that this area had been regulated in detail by a statute which passed by Parliament, so that it was not technically a common law case involving equity at all. So really, in a sense, they were trying to decide whether they should create exceptions to the statute. The statute itself already, of course, contains some equitable ideas that she should not be evicted from her home without due process. But if I may say so, I think a lot of equity is about fundamental rights. I think a lot of it is. And that when courts of equity intervened in the past using equitable doctrines, they didn't use the language of human rights very often, but they were, I think, very interested in people's property rights, the right to their home. And if I'd had time, I would have mentioned the De Francesco and Barnum case where they do mention human rights. This is the case where a court refuses to order specific performance of a contract of employment of a young woman who had become a dancer in a circus. They refused to force her to carry on the ground that this would be a contract that would amount to slavery. So by the late 19th century, the English judges recognized that forcing people to work was a violation of their human rights, though they hadn't spotted that point for the previous 1,000 years, I have to say.
Yeah, please. Yeah.
Thank you very much, Professor Collins. So you mentioned if the court take into account fundamental rights, this would not necessarily change a lot of the case outcomes. But I see that the problem is, whenever a claimant cannot get something out of the existing common law or private law, they will try to ask for creation of some new action, just as we saw in the Campbell case. And also, arguably, if the Canary Wharf case was decided in exactly the opposite way. So there seems to be a rational pressure to push the boundaries of the private law broader and broader, until we perhaps get to a point where the human rights will become directly actionable. So do you see that happening? Because whatever that is not dealt with under the existing private law will have to be pushed wider and wider until perhaps at one point the fundamental rights will be directly actionable.
Well, I'm certainly in favour of using fundamental rights to question established doctrines, but at least in England, the judges are normally pretty conservative and don't want to change the law very much, very fast, and I think that's probably a common phenomenon. So I'm not really very worried about the possibility they're going to make radical changes. But what I think it does do is two things. Forces them, first of all, to think, are we really doing the right thing here? And secondly, it gives them a way of explaining how to change things. So in the MacDonald case, for example, with the young woman, I think they had an opportunity there, if they'd taken it, to make a very minor change to the law of landlord and tenant, just saying in exceptional cases perhaps eviction should not be permitted. But most of the cases I've talked about, they've decided in the end not to change the law or not change it very significantly, haven't they? The Hunter case, the Hunter and Canary Wharf, it's interesting that the dissenting judge, Cook, came from New Zealand. He had no problem with the idea that a fundamental right was being interfered with. It was the English judges who hadn't really understood the point at that time. I think I've answered your question. I think. Have I?
Thank you, Professor Collins. Because I'm from mainland China and I'm basically a civil law background, so I'm quite interested in your mention about the horizontal effect, because we know that under the German constitutional law, horizontal effect is really developed from the case, I think, Lut. Yeah, and that basically means they really have some general clauses in the German civil code, and then they have the power for the judges to interpret that general clause in light of the constitutional law. So do you think that is the rigidity of the existing doctrines in the common law system, I mean English law particularly, that make the application of fundamental rights in the private law cases more difficult? Because you generally have some terms such as public policy, but it might not be directly linked to the principles to protect the fundamental rights. But in some countries, put more emphasis on the legislative flexibility. They have general clauses, and then they can directly interpret that. So I want to know your thoughts about that.
That's a very interesting question. I left out about 3 pages of my lecture addressing that, so I'm glad you've raised it. So, yes, the idea of indirect effect is invented by the Germans because otherwise it's very embarrassing, right? So what they've got in Germany is 2 courts, the constitutional court and the private law court. And they were having a fight about who could interpret the law, and so the reconciliation is to say, well, the constitutional court says one thing, and then the private law courts will actually decide the case finally by interpreting private law in the light of what the constitutional court has said. So that they both want to be top court, and this is a way of reconciling it. There's a further problem for the civil law courts, which is they're not supposed to make up law. They're not supposed to create new causes of action. Everything is supposed to be done in accordance with the code. None of these problems affect the common law systems, where we have 1 court, not 2. We don't have a code. So what's so striking, I think, about the decision in the Campbell case is the Supreme Court in England, the Supreme Court doesn't seem to care whether it's indirect effect or direct effect. It pretends it's not creating a new tort, but it is, and it doesn't really worry about this. Whereas a German court would be very embarrassed. It couldn't possibly create a new tort. It would have to say that this is a new meaning of a particular provision in the code. So the English courts have, the common law tradition is, I think, one where the idea of indirect effect ultimately makes no sense at all. It's incomprehensible to a common lawyer when you look more closely, because common law judges can make up new rights. They don't do it very often. They're very reluctant to, but if necessary, they can. Ask yourself about, I don't know if you still, do you study cases like Donahue and Stevenson? Yes, do you? That's the one case every student seems to know. So what did Lord Atkin do in that case? Did he interpret the existing law, or did he create a new tort? Who knows? Who cares, right? Now that would be terribly important in a civil law system, Because if he created a new tort, he would be rewriting the code, and that's not allowed. But if he's just developing the common law in the light of policy or fundamental rights or the Bible, in that case, love your neighbour, whatever he's doing there, it doesn't matter. So in my view, indirect effect doesn't make any sense in a common law system. The only reason people talk about it is because they think it will pacify people who are alarmed about the introduction of human rights into private law cases. But I think it may pacify them. It may fool some of the people some of the time, so that's all right. But actually, it's false news. It's not true that what the courts are doing in England is not in direct effect. It is direct, but very marginal. Very marginal. That's a very brief answer to an important question. So I don't know how it would work out in mainland China. You might well have to follow the German approach, which is to say that the way you insert fundamental rights into private law is you use general clauses of the code, general statements like people should behave with morally or in good faith or something like that. You just say, well, that means they must respect each other's fundamental rights. So you could do it that way.
Thank you, Professor Collins. I have a comment and a question. My comment is that you're making a distinction that in the private domain, the human rights or fundamental rights, they could be a contest. One human right versus another human right. In a public domain, this is unlikely. So my comment is that in a public domain also, that is quite possible, and it is already happening. One concrete example I would like to give is that a company called Novartis, it challenged the Indian Patents Act on the ground that it is unconstitutional. And the company was relying on a fundamental right of equality as well as right to property, and the Indian government was pleading right to health. And that's why, I mean, this is just one example, but there could be numerous examples where even within a public domain, the issue of one human right clashing with other human rights could arise, and then the question of proportionality and the striking a balance would become relevant. So that is just a comment on the distinction that you were trying to draw. My question is that I'm willing to be persuaded by your argument you're making in relation to the constitutionalization of private law. My question is, will you extend the same argument to a reverse situation? Reverse situation is privatization of constitutional law. Instead of aligning private law to the norms of constitutional law, what if the constitutional law rules have to be aligned to private law? The reverse of this. So will you be able to extend this argument to the reverse scenario? Thank you.
Thank you for the point about patents. I think yes, I need to be a bit careful that certainly in a public law context where the government can, of course, try to defend its actions by saying that it's pursuing a legitimate aim in a proportionate way, that sort of argument. And the legitimate aim might well include the protection of the rights of people or their welfare or whatever it might be. So certainly the government could do that. But my view is it's not quite the same process there as balancing the fundamental rights of two individuals, which, if you want to know the technical difference, it's in the private law context, it's a double proportionality test, and in the public sector, it's only a single proportionality test. So that the way it works in private law is you try to find a solution which minimizes the interference with both parties' rights. Whereas in public law context, the question is whether the right is being interfered with for a legitimate reason and whether that's a good enough reason to interfere with it. So I think that it is, it is different, but I agree there are similarities there, and certainly governments are likely to protect the rights of individuals. As regards your main question, this sounds pretty horrific to me. That what are you suggesting? That we privatise government and say that because which of course we've done, yes, and that these private agencies don't have to comply with any rule of law, fundamental rights, or anything. I'm just trying to remember how far Mrs. Thatcher went down that road. She was much more interested in saving money than taking people's rights away, I think, though she did a bit of that as well. But do you have a particular example, perhaps a local example, where things have been privatised, government functions, and thereby...
talk later because we are...
Yes, okay, yes. But in principle, no, is the short answer. I think that sounds like... No, I'm in favour of the rule of law, human rights, and I think human rights should apply to all aspects of the law, yes. Simple.
Next question.
I just have a question and perhaps a concern that you are understating the sort of impact that fundamental rights can have on private law. In South Africa, for example, it's a requirement that the Bill of Rights is taken into account every time a court considers a dispute. And this has translated itself into contracts of freedom of contract being significantly limited, and also the freedom of testation as well, to such an extent that oftentimes contracts become indeterminate. Prenuptial contracts which were agreed freely before marriage 20 years later are essentially nullified because an interventionist judge decides that this doesn't appear fair to him or her in that case. Same with law of succession, 2 cases you mentioned. In Andorra, for example, something similar happened. I'm just kind of concerned. I would like to have your opinion on what sort of limits would there be to the sort of interference of fundamental rights with the private law rights.
Well, South Africa is a very interesting example, and I don't think I know enough about it really to speak authoritatively, but what makes it interesting is that in the Constitution itself, it endorses constitutionalization of private law. It says that the rights of the Constitution apply to private law without apparently any limitations or of any kind. So South Africa is boldly setting out on a road that nobody's gone down before, and I think it's turned out to be a road with some potholes, yes, where things have perhaps gone wrong. So what advice have I got for the South African judges? I have thought about this, and I think I would nevertheless urge the South African courts to move in the slow way that the English courts in their legal reasoning do, namely that you sort out the private law situation first, you apply the rules of private law, and then you smell it, as it were. And if it stinks, if it doesn't seem right, you then have a think about whether the fundamental rights might be brought in. So you don't shoot from the hip, bringing the fundamental rights out straight away. You move slowly, and in that way I think you have a progressive improvement in private law. Whereas some of the South African judgments I've seen, they kind of jump in, and particularly when you've got social and economic rights, like the right to housing and so on, that could lead to all kinds of unexpected consequences. But we watch South Africa with bated breath, as leading the way in this field. So thank you for reminding me of it, yes.
Okay, so let's thank again Professor Collins. Okay, thank you. Thank you very much. Thank you.
Thank you.
Thank you.